did 4 years of active duty in the United States Navy when I was commissioned at graduation. And I went to Boston College Law School for 1 year while I was in the Navy, and then transferred to NYU Law School and graduated NYU Law School in 1964. Came out here to Seattle from New York in August of 1964 to work in Governor Rossellini's office on a Ford Foundation grant through the National Center for Education and Politics to study state government. But then I got a job on the state Supreme Court as a law clerk, and that is a very treasured position. This case in 1964 or 1965 involved 2 Seattle police officers getting off duty at 8 o'clock, but put on Hawaiian shirts and met their wives and went out drinking. And finally they ended up in the Lin Yin Cafe and for dinner. There was a black couple sitting there, and one of the officers said, "I don't like to eat around N," in a loud voice. They had admitted to having at least 5 or 6 drinks apiece earlier in the evening. And he said it louder and louder again. So the male got up and called some friends. And some of the brothers came down, and there was a fight in the Lin Yin Cafe. The fight was over, and Robert and another individual got in the car and was leaving the Lin Yin Cafe parking lot. And one of the officers who had been in the fight came outside, stood next to a uniformed police officer, and shot into the car, shot a bullet into the dashboard and a bullet in the hand. The jury found justifiable homicide because they claimed that one of the weapons that was being used in there was a dish, and that dish was used in the fight. A civil case was brought by Dave Roderick and Jack Tanner. I think many of you remember Jack Tanner, who became a federal district court judge in Tacoma. At any rate, they lost the case, but they prepared the transcript of the trial and had filed a notice of appeal. But it sat languishing there. After I left the court, I became an assistant attorney general, and then I went out into private practice. And then I saw that transcript out there. I'll do it as a labor of love. And I got the briefs and argued the case in the state Supreme Court. And we lost. This Alfred Burnett had robbed Carroll Jewelry Store and was coming out of the store right into the arms of a police officer, a sergeant in the office. He had a record, but he was in jail. Through his attorney, he let it be known to Charles O'Carroll that he knew who the bummer was. Well, if you're in jail, there's a parole hold and you can't get out. But he got out. He had no such information, but he knew that both the police department and the prosecutor were being, a lot of pressure was coming on them because nobody could find out who the bomber was. Through the police department, they got dynamite, all right? The dynamite cannot explode without having a thing to make it explode. At any rate, he had this dynamite. They set it up so that right across from Hardcastle in the parking lot was a plainclothes officer. The police had examined the dynamite before, knew it wouldn't go off because there's no fuse to. They placed the dynamite, or he placed the dynamite Burnett went on, and then he stooped down to light the match. It isn't going to go off. The plainclothes officer from across the chute shot a shotgun, and it had one of those single shells that went into the window right above Larry's head. Larry got up and started to go down 24th Avenue. What had happened was that there were police all around the place. They allowed Burnett's car to go through, but here comes Larry, and he was shot to death. He's unarmed, but he was shot to death. I became involved in that inquest. The jury said on the questionnaire, yes, Ward died by criminal means. We were ecstatic. 3-2, Larry Ward died by criminal means. The old statute provides, if that's the case, then there should be an arrest warrant. The coroner should arrange for an arrest warrant and arrest the officer who was involved. No such thing was happening. Umpteen other cases followed about blacks being shot, and for some reason I got involved. But in the interim, before that, the rest of the cases came down, the freeholders had an election in Seattle, and they adopted a charter for King County, which provides that any time a law enforcement officer is involved in the death of a citizen, then there will be an inquest. So while there was no formal procedure outlined, the King County executive then asks the district court for the District of King County to conduct a hearing. One of the problems that we have with the inquest system is that the same police officers, the same police department does the investigation. All right, so that's kind of queasy. But then the prosecutor, the King County prosecutor, is the one that presents the evidence to the inquest jury. Well, the prosecutor already knows whether he's going to prosecute because he has the investigation. They say the inquest jury has no power other to answer some questions. It has one or maybe two good things going for it. Number one, there's a public airing, A-I-R-I-N-G. That differs from the grand jury that you used to have in Ferguson, all right? So because you have a public airing, then the press covers it, and you can go to court and you can watch this going on, except that the people who are represented there is the officer who did the shooting, the family of the deceased, and the prosecutor who is supposed to be impartial presenting the evidence. Well, let me tell you, they hide the ball sometimes. But at any rate, at least you get to ask questions. You can't make an opening statement and you can't make a closing argument. But at least you can have witnesses who were there saying what had happened. All right. Now let me give you, you think Ferguson was bad? Do you think that the one in New York where they choked out that guy was bad? Let me tell you the worst case that I've ever seen involved, and I've handled over a dozen of these inquests. One night, this young man, he's about 23 years old, sees his girlfriend, the mother of his child, and he's slapping her around. Well, she called 911, as she should do, because you can't have domestic violence. The fellow ran across an empty lot. Jumped over a fence and got hung up on a stanchion like this. All right? I'm really sorry that Dr. Donald Ray isn't here because I couldn't believe his findings. He said that the muzzle of the gun was between 12 and 18 inches from the individual when he was shot. A cop stood over this guy lying like that and shot him in the Adam's apple. Chief Stamper was the chief of police at that time. He came to the community and to Mount Zion Baptist Church, and he thought maybe, 10 or 12 people. 750 people were there. What is this shooting going on? He said, it's an unjustified shooting. The next day, he got the Shooting Review Board report. And you know what it said? It was accidental and within police guidelines. It takes 8.5 pounds of pressure to pull that trigger on the Glock. All right? That's no accident. But you know what it is? I've been pondering. This young officer didn't go to the central area. Well, I'm going to get a black tonight. You know what it is? It's fear. They don't know what, and they get scared. They don't know what happened. And that's part of their training, and that's part of it. The irregularities that went on from the prosecutor's office. Now, folks, you shouldn't speak ill of the dead, but I want you to know that I went to Norm Nailing and I said, you've got to prosecute. You've got to prosecute because here it was, the guy shot him and so forth. The inquest jury, because remember I told you that under the new procedure that was provided that there would be an inquest and that the families of the deceased and the police officer would have representation there. And I told you it's developed that you could not give an opening statement or a closing argument, but you could ask questions of the witnesses, so you had a public hearing. That is why our system of inquest is superior to the rest of the country, where they have a grand jury investigation, because you don't know what goes on in the grand jury investigation. We saw what happened in Ferguson. So the prosecutor, it is also a conflict of interest to have the prosecutor present the evidence because they have to work with these officers who bring in cases. And I've been screaming for years and years and nobody listens to me and so forth. But this last case in New York where the guy's choked out and had what Dr. Ray calls positional asphyxia, because he has a mass and the diaphragm doesn't get to expand, so he can't eat because people are on top of him and choking. Not only can he not breathe, but the diaphragm cannot get going. And Dr. Ray has written articles on this. Well, at any rate, after the shooting, I was also upset with our mayor. Our mayor was Norm Rice. And I pursued the chief of police because he said, I have received the chief of police report and I'm not taking any action because the report justifies the action. This is Chief Stamper that talks about community policing and everything. Norm said, I support my chief of police, number one, which was wrong. But then he said, we must also be mindful of the police officer's family. That's when I lost it. That's when I lost it. A young man is dead at the hands of a police officer, and we're not concerned about his family. We're concerned about the officer who shot him. Well, the Baldwin case involved a gentleman who had the police department calls him 220, who had mental problem, and they were going to evict him. Well, he locked himself up in the room and wouldn't come out. The manager of the projects went to the door, opened it, and a police officer to deliver the warrant, to evict him, went in, and Robert Baldwin stabbed him with a sword right through the chest. And that officer, of course, died. And the siege went on for 17 hours, and they had him inside. Well, they decided that they were going to, the SWAT team was going to go in. All right. They had tossed in some gas, tear gas and whatnot and so forth, and opened the door and tossed something in. And he came out, and I guess he had the sword or something, but there was a volley, a bullet. But that's not what killed him. He fell down. He fell down, and when he was lying prone, there was the officer with the gun, with the Uzi, pumping bullets into his back. He had 21 bullets in his back. I couldn't believe the report, Dr. Ray. I tried the civil case. Each officer on the SWAT team who was there was represented by counsel during the inquest. And the jury again found justifiable or excusable homicide because he had killed a cop and so forth. But the point was more than excessive force was used. I got a dummy, all right, one of those dummies from the stores, and I had holes poked where it was. And I said, I had Dr. Ray understand. So, doctor, somebody couldn't be standing up and suddenly turn and so forth. The bullets went through the body into the floor. Is that right? Yes, that's right. And so we had a trial that lasted, I don't know how long. The jury did a strange thing in the civil case that followed. They found that it was wrong for them to do, but they only valued his life like $2 or something. They said he was a killer. He had killed somebody and so forth. The SWAT team resigned in mass because they thought that the jury would say what they did was proper. So forth. Let me tell you, since you're interested, about the legal foundation of these cases. The civil cases that you have. The civil case is based on, or at least the Federal Civil Rights Act, Title 42, Section 1983. And that says if there is a violation of federal law, a case can be brought in it can be brought in federal court, but now the state also has jurisdiction. So that if there is excessive force that is used, they beat up somebody or falsely arrest them or something, it can come under the 14th Amendment and the Fourth Amendment. Everybody has a right to be secure in their person and their private papers, all right? And you can't invade somebody's privacy or their physical being. So you have a basis for the federal court. The problem we have, and since I'm no longer in federal court, I'm not afraid to say what is wrong with it. The federal judiciary is very autocratic. You don't get voir dire. You can't ask the questions that you can for jury selection, number one. And number two, they think they're there for important cases. That is, for cases involving multi-million dollars of corporations or cases that involve some of these terrorists. All right? They don't treat civil rights cases as cases of significance. Although some judges like the chance to have a trial, they don't have very many trials in federal court. There's always plea bargains and whatnot, so they don't have that. And so that is my criticism of the federal court. But you said, well, why don't you bring it in state court? State court is ideal. Why? Because you can voir dire the jury. That is, ask prospective jurors questions. What are some of the questions that you can ask? I once asked, Miss Green, do you believe cops ever lie under oath? Oh, objection, objection, sustained. That's because the judges are not used to frank talk. If she, Miss Jones, doesn't believe a cop can lie under oath, then my client cannot win, right? Because there's a conflict in the testimony. So you have to approach it a little bit differently. Well, Miss Jones, would you subject the officer's testimony to the same with the same scrutiny that you would subject somebody, any other witness, and so forth? And you have to find ways of getting around conservative judges, because what they say, what the judges say, you're governed. You're free as the bird out here. You can work till 1, 2 o'clock in the morning. You can work on Saturdays and Sundays, or you can take off in the afternoon when it's sunny. And you say, well, being a lawyer, you're so independent. Not quite so, because when you're in court, you're subject to what the man with a black robe or woman with a black robe says. Getting around all of that, we discovered when we did focus groups. When you have a big case, you do focus groups. This is what all the commercials and everything on what the Republicans do and so forth. You have focus groups. So you have focus groups. You know what the focus groups said? 1/3 of the prospective jurors believe that cops can do no wrong. It doesn't matter. You know, don't confuse me with the facts my mind is made of. He's a cop and he's protecting me so he can do no wrong. 1/3 said, I wouldn't believe a cop if he swore on 500 Bibles. All right? And that's the other part of the population. And then finally you have 1/3 of the population that said, well, what happened? In the old days when I first started, I used to call it police brutality. But when you say police brutality, it shuts out prospective jurors. Why is it? There they go again, police brutality. So you say police misconduct. Oh, well, what's that? So at least you have their attention so you can talk about police misconduct. I am really sorry Jenny Durkin isn't here because she did marvelous as a U.S. attorney. Jenny Durkin started a lawsuit with the U.S. Justice Department to review excessive force by Seattle Police Department. And she's done that. And they now have an agreed order where there is supervision and collecting data of what has happened with the Seattle Police Department. So my hat is off to her. I hope that she would have become U.S. Attorney General when Eric Holder resigned, but it wasn't to be. I don't know the current occupant of that office. But let me tell you, this is an age-old stuff from the time of my hero, Thurgood Marshall. All right, Thurgood was fighting police brutality from years and years and years, and we know of his big case. And today is Martin Luther King Jr.'s birthday, and he changed thinking in this country by being perceptive that you have to fight it with nonviolence, all right? But Thurgood Marshall changed the laws in this country, in the states, by some 22 states where there was segregation. Once Brown versus Board of Education went and said separate but equal is not in fact equal, then that applied not only to the schools, but it applied in public accommodations and everything else. So, and that was 9-0. And that man worked his heart off all his life for equality and so forth. And all of that was the underpinning of when Martin Luther King Jr. came later, right? And he'd be sick. They talk about a post-racial society because we have a black president. Not so, you all. Racism is alive and well in this country. Why? Only 39% of whites voted for Barack Obama. And you saw what the minority leader, Mitch McConnell, said. His only goal was to oppose Obama. So what we had were 80% of the minority community, 96% of blacks voting for Obama. Pardon me. And then you had a lot of white women and younger people voting for Obama. But old white males did not vote for Obama. You can look at the figures. And what I'm telling you is racism is alive and well. And it always breaks down to this hunker down that they used to have in South Africa, right? You're with us or you're against us. And that's the mentality of the New York Police Department and the Guild, and our Guild here. It didn't matter how bad the situation is. They always support their own, and you have this conspiracy of silence. We've got to have community policing. Cops have got to get in the community and not be afraid of the people they serve. And you have to look at this. What is the motto of the police department? If it is to protect and to serve, then that sends the message to law. But if we're going to capture crooks and so forth, watch out. So what I'm telling you, it's very important. When you have police officers come to a community meeting, ask them, what is the motto of the department? Is it to protect and serve, or is it to, well, we're going to catch crooks and so forth and so on? Because then they don't care.